Participants, please give us 1 minute to set this up. Yeah, I think we're on.
Let me switch off.
Yes, I can confirm the page is not live.
All right, fantastic. Okay, let's start. So dear participants, hello and welcome to this MNC webinar on the future of commercial dispute resolution. I hope you are all in good health. For those who are not yet familiar with us, the firm, we are a full service law firm operating in Bangladesh for the last 25 years. I am Sake Mahbub. I'm a partner in the corporate and commercial practice of the firm. I'm really excited about the panel today, and I hope you are too. But before I introduce the esteemed panelists, I would just like to introduce the topic a little bit. So the future of commercial dispute resolution. Why are we talking about this today? The biggest reason, without a doubt, is probably COVID. In Bangladesh, for almost 2 months since the disease had broken out, we didn't have a single court or arbitral tribunal sitting anywhere in the country. We were not prepared for something like this at all. And we were found caught in a position where we were grappling for ways out. But in May, some very good leadership within the Supreme Court started the first ever virtual courts and the first ever e-filings even in Bangladesh. For many countries, these had been introduced already years ago, but for us, the transition was huge, as my panelists, fellow panelists would probably agree. But now that we have it, we feel like it's time to look forward to the next decade, or at least the next few years. And we want to discuss what we have learned during COVID and how we will use these learnings in the future and what in general lays ahead of us. We want to know what's happening in India, which shares the same legal and judicial ancestry as us. We want to know from what SIAC is doing, the Singapore International Arbitration Center, and the innovations that they are putting out there. And we must note that Bangladesh scores very poorly still in World Bank's doing business rankings when it comes to the enforcing contracts indicator. We are ranked at 189 out of 190 countries. Interestingly, India does very well in many other indicators, but when it comes to enforcing contracts, I think India is not ranked quite high either, not too ahead of us. But India has made some very transformative amendments to the Arbitration Act, which hopefully Sham sir or Shweta could shed some light upon later on. So now the panel, and I'm very excited to have these very esteemed panelists on this webinar. The first panelist I would like to introduce is Ms. Shweta Bidhuri. Shweta is the head of the South Asia operations of the Singapore International Arbitration Center, SIAC, and works out of SIAC's offices in Bombay. Before joining SIAC, Shweta worked nearly a decade in a leading Delhi law firm, where she was heavily involved with commercial litigation, investment treaty arbitrations. Shweta, it is a great pleasure to have you here today. Welcome.
Thank you for having me here. Thank you.
The next panelist I would like to introduce is Mr. Mustafizur Rahman Khan, Barrister at Law. Mr. Khan was called to the bar in England and Wales in 1997, and then he has since then been practicing in the Supreme Court of Bangladesh. He has been associated with some of the top law firms of Bangladesh, like Lee Khan, Dr. Kamal Hossain and Associates, and Rokun bin Mahmood and Associates. His areas of expertise are constitutional law, administrative law, commercial law, corporate law. He regularly appears before both divisions of the Supreme Court of Bangladesh. In fact, I saw him virtually moving a matter in the appellate division just this morning. He has also represented parties in investment and commercial disputes in ICC and ICSID arbitrations. Mustafiz sir, as I call him, also taught me government and politics in my A-levels, which I mention at every opportunity I get. I am very happy to have him here. Mustafiz sir, welcome to the webinar.
Thank you very much. Good evening from Dhaka to my fellow panelists and whoever has taken the trouble to tune in. I hope that all of you are keeping safe and healthy during these troubled times.
Thank you, sir. The next panelist I would like to introduce is Mr. Muhammad Rumee Ali. Mr. Rumee Ali has been the chief executive of the Bangladesh International Arbitration Center, BIAC, since 2015. But this was after a long and illustrious career first as a banker. Mr. Rumee Ali joined ANZ Greenlace Bank in 1975, and he was the first Bangladeshi to be appointed the CEO of the bank's Bangladesh operations. Mr. Rumee Ali then moved on to the central bank in 2007, where he worked as the deputy governor of the Bangladesh Bank before taking over the role of heading the enterprises and investments at BRAC, the world's largest NGO, and during which period he was also the chairman of BRAC Bank and the founder chairman of bCash, Bangladesh's biggest mobile financial services company. And he was also serving in the board of BRAC. Mr. Rumee Ali is the current chairman of AB Bank and serves on the advisory board of Banglalink, besides his role of CEO of BIAC. Mr. Rumee Ali, sir, welcome aboard.
Thank you. Thank you for asking me over. Although initially I was a bit worried about whether to accept it or not, and I'll explain why a little later. But thank you very much, and hello to all of you, and thank you again for asking me.
We'd love to hear that, Rumee Ali, sir. And last but not the least, I'm delighted to introduce Mr. Shyam Diwan, Senior Advocate, Supreme Court of India. Mr. Diwan is a prolific litigator, arbitrator, and speaker. He has appeared for citizens groups in environmental cases and assisted the Supreme Court as amicus curiae in high-profile cases. Mr. Diwan acted as counsel in the recent Aadhaar case concerning constitutionality of the Aadhaar card, if I'm not wrong, and Mr. Diwan can correct me if I'm wrong. He has co-authored a book called Environmental Law and Policy in India, and recently a chapter on public interest litigations in the Oxford Handbook of the Indian Constitution. He has taught at the University of Mumbai and also lectured at the National Law School of India in Bangalore. Mr. Diwan was elected the Vice President of Law Asia in 2018. And incidentally, that is where I met Mr. Diwan for the first time in a Law Asia event. Mr. Shyam Diwan, sir, very welcome to our webinar and really great to have you here.
Thank you very much. Greetings from New Delhi. I'm delighted to be here and delighted to accept Saqib's invitation. My greetings to all the co-panelists as well as the viewers. I'm looking forward to this evening. Thank you.
Thank you, sir. Thank you. First of all, I would just go straight into the discussion, and I would call on Mustafizur Rahman Khan to speak first. So commercial dispute resolution, we know, had come to a kind of a standstill. Virtual courts are operating on a very limited basis in Bangladesh, and arbitrations are not yet kicking off, considering the health and safety concerns. But we have started virtual courts. Appellate division has started in full swing on almost virtually this week. So considering this context, what long-term impacts do you see this having on the dispute resolution landscape in Bangladesh?
Okay, first of all, I think insofar as commercial dispute resolution is concerned, Bangladesh was not in a good shape even before the COVID-19 pandemic started. You mentioned that Bangladesh lags behind in the rankings globally insofar as it comes to the enforcement of contracts. And yet there is no gainsaying the fact that the development of a country is intrinsically linked to the efficiency with which it can resolve commercial disputes. Bangladesh has had problems which I am sure India has also faced, backlog in litigation, the inability of subordinate judges in particular to grasp commercial concepts. They are more familiar in dealing with criminal cases and land-related litigation in Bangladesh. So we were already struggling before COVID-19 came. Then when COVID-19 came through, for a period of about 2 months, courts in Bangladesh were not functioning at all. And then due to the very exceptional leadership of a few judges of the Supreme Court of Bangladesh in particular, and also I understand the support of the United Nations Development Program, we have been able to come up with a, I would still call it stopgap measure, where we are having courts virtually in Bangladesh. But even then, the scale at which the courts are operating in Bangladesh is still very limited. in the sense that in the Supreme Court of Bangladesh, the High Court Division, the single benches are, we only have single benches which are functioning virtually and which are basically dealing with interlocutory matters on an urgent basis. Full-scale hearings are not yet happening in the High Court Division. In the Appellate Division, during this week, they have the Appellate Division has started hearing full-scale appeals, and today they also heard a lot of interlocutory matters. As far as the subordinate judiciary is concerned, yes, again, urgent applications are being heard, but has also been some inconsistency with which the directions of the Supreme Court have been applied. So for instance, when it comes to criminal matters, some of the virtual courts are accepting surrenders, some of them are not. Some of them are dealing with only bail applications which relate to those who are already in custody. So we are having teething problems, but nonetheless, I am somewhat of an optimist when it comes to the future. I think that the COVID-19 crisis, as far as the legal system of Bangladesh is concerned, may well have a silver lining. I think that the COVID-19 crisis has forced our legal community to at least familiarize itself with information technology. Bangladesh's legal system is a legacy of our colonial past, and substantively, the way in which the legal system works has not seen any major change in the past 100 years. But with the advent of what are being called virtual courts in Bangladesh, we have already seen some revolutionary impact. I am a practicing lawyer. I mostly like to speak through anecdotes. I think something revolutionary happened in Bangladesh in the midst of these virtual hearings, something which even the judges themselves perhaps not yet realize the revolutionary impact of this. You see, in some of the matters before the High Court, lawyers who have found themselves abroad when the pandemic began, so far afield as Britain, as Switzerland, as Australia, they have also virtually appeared before the courts. Now, why is this a revolutionary step in the context of Bangladesh? You see, when we speak of courts, we basically think of a physical establishment with a certain paraphernalia. Courts, we think of courts as places. But for the first time, with the advent of a virtual court, we are looking at a court in terms of what it does. So the courts are a service. The courts are a service, excuse me. Courts are a service. Excuse me. The courts are a service. Excuse me, I'll be back in a couple of seconds.
This is the new reality of how things go, sir.
My apologies. my son was intruding. His 5-year-old. It's about his bedtime is coming up. My apologies. So what the point that I was trying to make is that now we are thinking of courts not in terms of a physical establishment, but rather in terms of what they do. And what courts do is that they provide a service. I think now, going ahead, people in Bangladesh will start thinking in terms of how better the legal system can provide that service. I think going ahead, I can see that there will be greater use of information technology, not only in terms of the automation of the process, which are intended to introduce efficiencies, but perhaps more importantly, the digitalization of the courts will lead to more transformational measures. So for instance, going ahead in terms of alternative dispute resolution, I can foresee that arbitrations will not only be held digitally, but also, for instance, Professor Suskind talks about developing different decision-making models where you can provide input in a software and certain disputes can be resolved even through with the help of digital technology. So that is one thing. So I am somebody who wants to look at the glass as being half full as opposed to half empty. And I believe that once the pandemic is over and we reflect upon the process through which we have gone through in dealing with it, we will find out new ways of innovation, new ways of using information technology in order to introduce efficiencies in dispute resolution in Bangladesh. Having said so, there are certain other problems which come. For example, now there is a movement amongst lawyers, a segment of the lawyers who wants the regular courts to resume with social distancing protocols, of course, but others fear that these are premature. The main reason why this movement is happening is that in Bangladesh, there are also problems of digital exclusion. For instance, everybody is not familiar with the technology. Everybody does not have access to the technology. So those would be some of the challenges that we would be facing. But I think that the crisis through which we are going right now will have a transformative effect on our legal system. And going ahead, not only will efficiencies be introduced in our legal system, but also going ahead, we will find more ways in which we can actually transform the way in which we provide the service.
Speaking of innovations and new ways of doing things, so Zoom allows us to have a poll, and I'm really excited about this new technology. And we wouldn't be able to do this in a physical seminar. So we just have a poll out. So this just continuing from the debate that you mentioned, whether VCs should be should stay on and there's a movement. So we have a question. Let's just put it out there, and so our participants who are joining from Zoom can vote. So the question is: are virtual courts a temporary fix, or should they form a permanent part of justice delivery in courts? Panelists can also vote. Just launching the poll, and let's see what our participants have to say about that. And so while we are voting, I'll just. Is there an echo? Is there an echo from?
No echo.
Oh, okay. Okay. So so the next. So let's just wait 30 seconds for this poll to happen. Okay. Okay, so can everyone see the results? Okay, so we have, so one of the answers was VCs are temporary and should be abolished after the pandemic. No one voted for that. VCs can stay on, but on a limited basis only. 76% of us think that should be the case. And VCs are the future and should replace most physical courts. 33% of us are thinking that way. So great. Perhaps Mr. Shyam Diwan, you could respond to that. And also I would like to, in addition to what I had asked Mr. Khan, which is about virtual courts starting in Bangladesh. Also, if you could just shed some light upon how India has dealt with this issue. And obviously there was some use of technology in Indian courts. We have heard there was e-filing going on in some high courts. So how has that actually gone on? And India actually started virtual courts, I think at least a couple of weeks before us. And we showed that as an example when we were asking for virtual courts, so in Bangladesh. But after that, I have a question. So where we're now talking about more video conferencing in courts, in arbitrations, and now we're only dealing with, say, things like interlocutory orders. But at some point, we will be dealing with, say, witnesses and evidence in video conferencing. And where do we actually stop with this? Or do we stop at all? Do we need to stop somewhere? We've always heard that, with it cross-examination, you have to look at the body language of the witness, the demeanor, etc. Is that something that's going to be that we're going to miss out on, and is that a problem? And also for emerging practitioners, so junior lawyers, it's such a great opportunity to sit in court or sit at the back of an arbitration, listening to the hearings, how seniors are doing, and maybe going up to them while they're having tea and networking, etc. Are we missing out on that? And is there an issue with that? So yeah, Mr. Shamdivan, sir.
Thank you very much. Well, let me just respond to the many questions which you've given in first general terms, and just explain to you as I understand what's happening in India, and thereafter probably come down to some of the particular points which you mentioned. So you're quite right. We have started e-courts and e-filing in some of the high courts and even in the Supreme Court of India before the pandemic. So to that extent, there were judges, for example, I can say with confidence that a large number of judges in the Delhi High Court are extremely familiar with both the e-filing, and those courts are virtually paperless courts. So the High Court of Delhi has, at a jurisdictional level, it's both an appellate court, it has an original writ jurisdiction, which is a constitutional jurisdiction, and it also has an original side, an original jurisdiction, and therefore it conducts trials in commercial cases, etc. So it's quite a range of work which it does. And the justices of the Delhi High Court have been very familiar with e-filing. And there are certain courts where the only papers, insofar as the judge is concerned, this is pre-pandemic, was just the order sheets. So there's just one file of the order sheets, but otherwise everything in terms of pleadings, etc., was before on a screen. So that was an advantage in some of the courts, but it wasn't a widely prevalent practice across India at all. Post-pandemic, just as in the case of Bangladesh, as we learned, there was a considerable, I think, initiative displayed by both the Supreme Court of India as well as the high courts in trying to ensure that some degree of access to justice is assured, at least in the constitutional courts. And the manner in which that was done was that each of either the high courts or the Supreme Court, again, similar to Bangladesh, basically for emergency hearings, urgent matters, listed a small number of cases relative to the large volumes which we ordinarily would have, and heard those cases through a video conferencing platform. So there are different platforms in use in the high courts and in the Supreme Court of India. And I think having appeared before a couple of high courts as well as the Supreme Court, my experience so far as a practitioner has been that, well, yes, as a stopgap, it's certainly better than nothing. But I think we have a very far and long way to go. And the reason for this is two or three. The first is, I think in terms of access to justice, we have to realize that if that's the goal we're looking for, we have to combine that also with the open court hearing system. The open justice system is absolutely fundamental in most parts of the world, as I'm sure it is in Bangladesh. And this is becoming a little closed because, yes, you can have, everyone cannot walk in. And I think from a symbolic point of view, that's very important. The second point, and I here take the point which Mustafazir mentioned a short while ago, that look, when you're talking about access to justice, it's not just that last mile where in a Supreme Court or the High Court division, you are able to present your case. That's the final mile. That's important. But when we speak of access to justice, it's eventually, as was mentioned earlier, a service which we're all rendering. And for that service, It has to be a situation where the client can effectively meet his or her advocate. The advocate can then create that case, and then that case can be effectively presented before a court. This is just on the litigation part. And I believe unless we have very strong technological links right through the chain, right, starting from the client, this digital divide which was mentioned, or the digital deprivation, is a huge barrier to access to justice. So I would say that in its current state, as your poll reflected, maybe it can serve as some sort of a supplementary emergency means, but I don't think we have the general technology, one. I don't think we have in India the penetration, two. I don't think we have the general familiarity amongst eventually clients who are the most important people, and the confidence to use that technology even at the first round. So yes, we will continue spluttering along. I think in emergency hearings, I might just add that the Supreme Court has recently now transited to even final hearings, and we're making an endeavor to have long cases, etc., also heard. But as you can imagine, there is a huge technological impediment. It's difficult enough to persuade a judge, as I'm sure all the practitioners here would agree. And then when you have a screen intervening between you and a connectivity issue, that the psychological bond which is required to engage in order to persuade is really lost. I might just add one little point, and which is, of all the hearings I have had so far, the one which I found most satisfactory was in an arbitration. And I think the reason for that is it was structured, it was disciplined, everyone knew exactly who was to argue, when the person was to argue. It wasn't that great amount of pressure on the registry or the court master to move things along. And I think we could, since we could choose our time, we could choose our, the arbitrator was known, etc. We could identify the record. We could send advance lists of what we were going to refer to at the hearing. I think it went very smoothly. And I thought that was a pretty satisfactory hearing. But at the end of the day, I think unless there's a huge scale up, and I don't see that happening in the near term, pandemic or otherwise, huge scale up in technology, in acceptance of technology, in the distribution and availability of technology, I think virtual courts will be playing really a very small role. And I think at the moment, the way I see it, it's nice to know that your courts are functioning, but they are functioning at a fraction of the level. So it's nice to know that there is someone there whom we can go to. And I might just in conclusion mention that I made some inquiries before this panel discussion. And I found, for example, that below our high court level, we have only very selective physical courts functioning in our country at the moment. So the digital divide becomes very, very perceptible because all the huge number of lawyers and litigants who have cases in these magistrates' courts, in several of our tribunals, etc., have really nowhere to go. So that's essentially my response.
Thank you, sir. That was very, very enlightening. So we have Mr. Mohammad Rumee Ali with us, who is the CEO of BIAC, as I've said. Mr. Rumee Ali, sir, you had a very illustrious career in the banking sector. Then you came into BIAC in 2015. So how has BIAC transformed under your leadership? We would just like a few words on that. And also, since you might have to leave early, I'll just ask you as many questions as I can so that you can answer them all at once. So I just wanted to ask you first of all, how BIAC has also adapted to COVID, to the social distancing issues, but more generally in the last few years, and what BIAC looks forward to for the next few years. since the topic is the future of commercial dispute resolution. And specifically speaking, also, we've seen that BIAC has targeted a couple of sectors, for example, the banking sector, which is some sector that you are quite familiar in. I think and also recently there was some inroads into the export sector, if I'm not wrong, manufacturing and exports. And so how do you see that kind of playing out? And if you could also shed some light upon how you see mediation, because I think that is quite a priority sector for BIAC as well. How you see mediation developing in Bangladesh? Obviously, mediation is great in the way that it is non-confrontational and there's a win-win situation, but also there's issues that like it's not binding necessarily on the parties. So how do you see mediation developing and your role as an organization in that? Sorry for the loaded question.
No, thank you, Sakib, and thank you for inviting me. I'll let on why I said I was double-minded whether I should accept your invitation at all. I'm not a lawyer. I'm not a lawyer. It almost feels like I've gate crashed into a place I shouldn't be. And my only brush with law, if I can say it's a brush with law, was when I gave the associateship exam for the Institute of Bankers, which is the English Institute of Bankers, the basic law for bankers and law related to banking. But that was many, many years back. As you can see from my appearance, I'm not a young guy. So I think it was 25 years back I sat for those exams. So, but being a banker, I had always had to, deal with law and lawyers. And then finally I landed up with BIAC, where I became even more involved with the law in a sort of in a way. I'd say that the thing about some of the questions you asked, I'll go to your questions. I think this crisis, if you call it a crisis, for us is an opportunity. And by us, I'm talking about BIAC. Because I believe that this has given us an opportunity to show what mediation and arbitration can do. The reason is the legal process is very, it doesn't have flexibility. You have clear definitions of what is evidence, what should be presented in the court, what should not be presented in the court. That sort of ties you down in a big way. Where in mediation and arbitration, you have tremendous amount of flexibility to be able to set your own way of doing things. And that in this new, what you call the new normal, gives us an opportunity. For example, in mediation, you can have it virtually. Virtual mediation is not new. It's been happening all over the world. The reason, I got involved with the export sector recently, I will recount it, is the fact that we had a huge disaster with the garment industry over here, who had a lot of the international buyers refusing to, stick to the contracts they had with the exporters. They cited a lot of reasons, but I'll not go into that. But I had a chat with them and I told them that, look, this is the way to go about it, is not to go through the judicial or the legal process in this. You have to sit down and mediate with them, because you are talking about very, very big organizations. And not only that, the jurisdiction in almost all the contracts are in Europe or America. And for a $500,000 or a $1 million contract, if you go to those jurisdictions, I don't think, the amount of money you'll have to spend for a case might be astronomical, relatively speaking. So I think over here, mediation would work. And certainly if that didn't work, arbitration would also work. Again, multinationals are very, very sensitive about confidentiality. They also don't want bad publicity. So in both the cases, it would suit them to go in that direction. So I think, there was opportunity over there, and that's how I got. In the case of banking, Bangladesh has a lot of, has a legacy of bad lending. And we believe that the smaller, there are huge amounts and huge numbers of cases in the bank, which are outstanding in the courts. And it's draining the effort of the banks. It needs people, it needs, but they have to, by law, they have to pursue the cases. They cannot just write it off. They have to show, if they want to write it off, they have to show that they have gone to court and tried it. So there, some amount, this is inefficiency. For example, a 200,000 taka loan has to be pursued. Now, it's not efficient. We wanted certain reforms over there to change things. Now, while we couldn't do it at that time, I believe now is probably the time when this situation is here, we can try. The reason why I'm saying it is that the tendency of, this is something I learned as a banker when we went through transformations and changed our IT platform. And I went through 3 or 4 changes in the IT platform. And there I had a conversation with IT expert in one of those things who had come to help us to do the transformation. And he said that the tendency of the people is when they go in, when they face a transformation, when they sit with that person who has come to help them with that, they say that, I want you to transform a manual process into a computerized process. What we tend to do is just replace the manual process or the way we process something manually into a computerized process. For example, if there is a form to be filled in the manual process, we want that on the screen and we just want to complete that. Now, what he told me is not, you shouldn't do it that way. You should change your whole thinking about how to do it. Look at the end, what are you trying to achieve? It's much like our colleague speaker had said, that court is not a place. It's a service. It's the outcome is what you get. And I think that is how we should be viewing all these things. And we should not try to replicate what is being done now in the courts manually. We need to find a new model of doing that. I think that is what we are doing right now. We are just using our virtual presence to replicating what if we were there. The virtual court is just a replication of the real court. I don't think it's going to work that way. For that, of course, we need to change our laws as well. So the next step is to go and reform the laws. For example, physical evidence. Do we have to, for example, I remember in my days, I was told as a banker, I was told that when we brought the ATM machines to Bangladesh, I was told that a PIN, that's person identification number, you all know, you put the PIN to take out money from the ATM machines, that is not a valid signature. And when you put a PIN and withdraw money, actually, law doesn't actually let you do that because by law, a signature is a physical signature. So, at that time, at least we didn't have a law which said that PIN will be accepted by courts as a signature. But, we had to do a workaround, and the workaround was, of course, we agree. The two parties agree that if I put the PIN, it's equal to giving a signature. So that sort of was a quasi signature or whatever we agreed, and we crossed that bridge. But if we continue to consider that we have to have a signature, we'd have to send all the transactions back to the customer and take a signature. So the whole idea of ATM wouldn't work because it would bring inefficiency. So my thing about, I'm not a lawyer, you are, so you and the judges, I think there's a need for all the sects, all the people who are involved with the judicial system to see how we can use technology. Let me tell you, when I started bKash, there was a huge thing. How can you trust a phone to transfer money? How can you trust a phone to keep money? And I knew that most of the people who will be using bKash were the poor people. And that is the reality. The rich people do not have bKash accounts. It is the very poor people, the rickshawalas and etc. who have bKash accounts. Now, how did we, we decided that we are not going to do, we are not going to stop because we need credibility. We'll create the credibility by doing it for them. And so that we'll demonstrate that it's credible, and that way we'll get credibility. So this divide, this access issue, which I heard right now, I think this is something we cannot say that we will only start after we cross the technological divide and bring everybody within technology. You have to start now. For example, use the smartphone. See if smartphone can replace many of the things we do in a court. Maybe you can. So we started when smartphones weren't there. So we had the earlier phones which couldn't do a lot of things. Now with the advance of smartphones, cheap smartphones, BIAC has moved further ahead. I'm sorry, I'm not speaking your language, law, but what I'm trying to show is an outside layman's view of how we can change things. Going back to arbitration and what we are doing in arbitration, I think we are trying to use this intergenum, like BIAC has its own arbitration rules and mediation rules. We have changed them and adapted them for using virtual arbitration and virtual mediation. And we are ready now to start both arbitration, mediation and arbitration on a virtual basis. The problem is, of course, the arbitration and mediation has remained confined to individuals. Individual law firms do it. But there is no institutional arbitration, very, very low, the number of people who will come to an institution to do your arbitration. I visited SIAC, also the Indian Institute over there. I've been to the Malaysian Institute. They took time to, over time to get to the place they are in now. I think it will happen over here too. I think over time we'll get the acceptance that institutional arbitration is always better because you have governance, you have you have data which goes back, and it helps to develop the thing even further. So I think that is what we are trying to do, and I think over time, if we can convince people that we have the e-arbitration, e-mediation is perhaps better. And I want to use the example, as I said, of the garment and textile industry to start, because I think we have made some headway over there. They also understand that they cannot really take the judicial process or take the hard line with these large buyers. They have to try some of the process. And I think that will be a demonstration to at least a large number of corporates that this may be the way to resolve disputes rather than going to the courts first time. I think, it's going to take time. It's not something that will happen, but I'm hopeful like you. I think this has to come, not because of the pandemic, but because it is the way of the future. This is a very inefficient way of resolving disputes. And that is why we have backlogs. That is why we have 3.1 million commercial cases outstanding as of the middle of last year. So with that, I will, with all hope that future we can say, I'm sorry, I'll have to go. I've got an international call to, everything happens in the night for us because it's on that side, from UK, USA, they're all Europe. So I have to attend to a call. And so thank you very much. It's been a pleasure meeting you all and speaking. And I hope to see you again, Saqib. I'm open now. Thank you very much.
Thank you so much, sir. You said that that you apologize for not speaking our language, but I think we speak our language too much sometimes, and I think that is a problem. I think that is a problem.
All I want to say is that I hope I made sense. In some
you really did. You really did. And just when we were discussing the virtual courts in the beginning, in the month of May, and I think for 2 or 3 weeks, we were just talking about what laws we need to change to introduce virtual courts. And in the end, it was just a very simple practice direction from the Supreme Court and an ordinance from the government. Thanks to the government for that, which happened in a matter of days. It didn't take long at all. If you have the will, then you can get around these issues very quickly.
Absolutely.
Thank you so much. Thank you so much for joining us, sir. And
it's been a pleasure. Thank you.
Yes, thank you so much. But carrying on from what you were saying, efficiency and flexibility and things like that in dispute resolution, and so with the possible global recession coming up, Shweta, if you would like to shed some light on this, how do you think clients in general and also lawyers would think about moving towards institutional arbitration, which obviously offers more perhaps efficiency, and how how SIAC has responded to COVID, and if you could just take us through some innovations, like we've heard of document only arbitrations, and we've been hearing of like fast track arbitrations. So what's in store for us from SIAC?
Thank you again, Saqib, for having me here. And I think because of the pandemic, the world is much closer and it's easier to meet everybody from different jurisdictions, rather than waiting to fly in and out. From SIAC's perspective, I think one thing I can say that despite so much of instability that there has been due to the pandemic, I think institutional arbitration has provided as much stability as possible. And I think amongst the different dispute resolution mechanisms, if we look at the courts, we look at mediation, arbitration, etc. It's really the arbitration which has been able to respond in the most efficient manner. And the reason I say that is because for arbitration, this was not something absolutely new. Virtual hearings were not something, a completely new format. In fact, in international commercial arbitrations, there were already so many cases where virtual hearings were taking place. In fact, in certain cases, even cross-examination of witnesses had taken place by virtual hearing, where because of the visa restrictions, etc., the witness was not able to travel. So, but because of the pandemic, I think we've been able to truly test the efficiency of arbitration, and primarily because of the institutional mechanism that is there in place, there have been least amount of disruptions. So, of course, when the pandemic hit, there were a lot of questions about what will happen to the hearings. The first response was to adjourn them, but then you didn't know how long you had to adjourn them. How long is this going to span out? In some cases, parties asked for extension of timelines where the submissions had to be made. But I think gradually with, when everybody realized that this is much longer than we thought it is going to be, everyone adopted the mechanism for virtual hearing, and they quickly adapted to this new way of resolving disputes. Amongst the from the institutional standpoint, of course, we quickly moved things to electronic. So all the filings moved electronic. Parties were able to initiate arbitrations electronically. Their payments could be done by bank transfers, etc. So that at the more semantic level, but inherently the procedures already provided for ways in which there could be efficient and effective arbitrations. So like you mentioned, I think one of the most popular mechanisms during this time that we've seen is expedited procedure. So I think because there's going to be lesser money in the system, already we're seeing the effect of the pandemic. And even after the pandemic is over, liquidity is going to be the biggest concern. So when you have limited money, you are, of course, going to be concerned about the cost effectiveness of the dispute resolution mechanism that you adopt. Your time, you want to have things resolved faster. Right? You don't want to be caught up in a system where your money is locked in. So there have been different mechanisms, such as the expedited procedure, which also allows for parties to have documents only arbitration. And interestingly, I think this shift from, particularly from India's standpoint, maybe shift from too much focus on oral advocacy to now move to written advocacy. And I think I've seen, at SIAC itself, so many cases where parties have agreed, jointly agreed to move to documents only arbitration wherever possible. If it's not a very complex case, they have very willingly moved to documents only arbitration. Interestingly, even the use of emergency arbitration. So otherwise, like you were seeing in Bangladesh, you see in India, and in fact, different other jurisdictions, the courts are functioning to a limited capacity. They're not hearing day-to-day matters. So even when you need a relief, an urgent relief in a commercial matter, it would not be easy to go to court and obtain that. And of course, there are the concerns of confidentiality, etc. So how emergency arbitration has also emerged as one of the more popular mechanisms that parties have adopted. Of course, there have been a lot of cases, different fact scenarios that have emerged because of COVID, invocation of bank guarantees. There have been, of course, disruptions in the contracts, etc., and parties needed urgent release. So, that only institutional arbitration is able to provide for. Another very interesting, when you talk about the liquidity standpoint, is the use of ARB-Med-ARB procedure, which allows where parties would want to try and settle the matter. So even once the arbitration has commenced, there is a conscious approach that they would like to settle the matter. So how ARB-Med-ARB would allow parties to be able to mediate even after the arbitration has begun and have a binding award once there is a settlement between the two, which is turned into an award which will have the same force as the New York Convention award. So of course, there have been different mechanisms that have been in place, but looking at the future, I think parties are going to, in their contract, see more institutional arbitration, because of the nature and the uncertainty that they have faced at the moment. And I think that will truly provide the answer that is needed at the moment to be able to have most efficient response, not only from a short-term perspective, but also from a long-term. So these are some of the things that I feel, of course, we are going to use technology. We've moved virtual, and even the virtual hearings are likely to stay, even once the pandemic is over. Of course, where you need to, parties would want to come together and see each other face to face, meet the tribunal face to face. But wherever possible, they will try and dispense it. So I think that filtration of the process of what you actually need versus what you can do without is really going to come out much more clear with the advent of time. And I think it's so important for everybody to learn from what choices we make in the present to ensure that the future is not suddenly also uncertain as it was, when the pandemic hit. I don't think none of us, would have seen something like this in our lifetime or would ever see something like this. So, but to be able to be prepared is what we need to do. And I think institutional arbitration, because it is able to foresee so much into the future, it is more ready than any other mechanism to be able to deal with the realities that are going to span out.
Thank you, Shweta. I think I agree with you. It has to be really justified. A physical hearing now, I think, needs justification as opposed to the other way around. Because if someone's now, I feel like after post-pandemic, if someone calls me in, a client calls me in for a meeting, I'd ask him to justify a meeting as opposed to a Zoom call. So I think with arbitrations particularly, since it is flexible and it is it is the party's will that is paramount. We will really move on to these virtual hearings more and more, with physical hearings probably being an exception when especially when parties are cross-border and they're the American party, why would he come to Singapore, etc. Right? So before I move on, for participants, we will have a brief Q&A at the end of this session. So please post your questions. If you're joining from Facebook, you can post them on the Facebook comments, and if you're joining in Zoom, you can post them in the Q&A or the chat option, whichever you prefer, and we'll take them up when we get to the Q&A part. But you can start posting your questions now. So moving to back to Mustafi sir. So cost, as Shweta said, costs are a big issue with now efficiency being paramount in importance. Costs, time, etc. And these are things that we haven't really solved in arbitration in Bangladesh. Is it? Arbitration is quite expensive. I have clients who have come to me and said, I'd rather go to court because it's cheaper. Arbitrators are expensive, and it doesn't necessarily take less time because there's so many almost appeal procedures with the setting aside stage. So what do you think? But we haven't really gone into reforming our law much in the last decade. So what do you think needs to be done in the near future? And do you actually see these reforms happening? Do you think COVID will give a push to some of these reforms? So I think you're mute.
Yeah. First of all, as far as the impact of COVID-19 is concerned, I mentioned that this has the potential to have a transformative effect on our legal system. For the first time, judges, lawyers who have been working in a particular way for tens, hundreds, almost more than 100 years, they have had to adopt and start becoming familiar with information technology. As far as the cost aspect is concerned, I think in order to make, first of all, arbitration more effective, more attractive, you have to make litigation more expensive. One of the difficulties in Bangladesh, for instance, when it comes to commercial and civil litigation, is that costs are usually not awarded in cause. So the losing side does not really pay the bill of the winning side. So that's an incentive for people to prolong litigation through the civil courts in order to be obstructionists. So that is one aspect of the matter. As far as arbitrations are concerned in Bangladesh, I think one of the great failures of our legal fraternity has been the failure to establish an institutional arbitration in Bangladesh. Most of the arbitrations in Bangladesh are still conducted on an ad hoc basis. Most of the arbitrators are not specialists in the sense that apart from arbitration, some of them are legal practitioners. Some of them are retired judges with due respect who have some perhaps antiquated ways of looking at things. As far as the legal practitioners are concerned in Bangladesh, the legal market for legal services has not developed in a way where there is still specialization in different corporate areas. So you will find somebody who practices in the day in the courts is practicing in arbitration during the evenings. So arbitrations in Bangladesh has become, it mirrors the civil process where dates in arbitrations, the calendars of all the lawyers and the arbitrators, they coincide only once a month. So you get the same process, lengthy process that you get in the civil courts being mirrored in the arbitration. The only point, as you have mentioned, is that sometimes they are more expensive. So I think the challenge is for our legal fraternity to make arbitration more attractive. And I think Bangladesh Institute, the BIAC so far has been making an effort, but it can certainly make more of an effort. The thing that I would like to highlight is this, that much of the change in Bangladesh would actually be driven by the requirements of globalization. Bangladeshi businessmen must realize that if they fall behind the global community when it comes to attaining efficiency in dispute resolution, then that would set us behind economically. And by the same token, those involved in the legal fraternity should think of ways in which the arbitration can be made more attractive in terms of dispute resolution. So certainly the costs associated with arbitration in Bangladesh practically is actually a dissuading factor when it should be a factor which persuades alternative dispute resolution. I think some of the issues that have been mentioned by the other panelists, picking up on them, I think if a younger set of arbitrators are now appointed by different lawyers representing commercial interests, then we can see the advantages of efficiencies offered by information technology, these coming through, so that alternative dispute resolution in Bangladesh becomes much more attractive. as a means of resolving disputes. I think as far as the courts are concerned, I hope that certainly when it comes to commercial litigation, the court starts awarding costs in cause. This is a great weakness, in my opinion, of our legal system. If substantial costs are being imposed, or even actual legal costs are being imposed on the losing side, then that would, first of all, reduce the load of litigation in Bangladesh, number one. Number two, it would give an impetus for client to take advice before escalating a matter to litigation. And it would also persuade people to explore alternative dispute resolution more.
So there is a big role, as you said, of how the courts are operating, because on the arbitration process, and that takes me to Mr. Divan. How we have seen we've heard of some amendments to the Indian Arbitration Act, I think you have spoken earlier on interference of the court on arbitral awards at the setting aside stage. So how do you see the recent amendments actually improving the situation? We've heard of, say, fixed timelines for arbitrations to be finished, appointments of arbitrators being kind of delegated to these court-appointed arbitral or court-recognized arbitral institutions. What impact do you see these having, or have they already been having an impact in India?
Well, I think a couple of points right away. The first is that I think I agree with all the other panelists who say that the way forward really is with regard to institutional arbitration. So this becomes a very, very important shift which we must make. The government of India, again, with a view to ensure that the enforcement of contracts and the ease of doing business in India improves dramatically or substantially because of the very low number, the low score which we have, has introduced reforms in the form of commercial courts. So that was one set of amendments, and amendments to our arbitration law. And you correctly pointed out that some of the major interventions by the legislature is, number one, interference by the courts has to be much, much less. Secondly, you have a situation where you have timelines which are prescribed, and there is a hope that with these two changes, more people will move towards arbitration. Now, there's something which I must share, because I think our problems are not probably dissimilar to what you have in Bangladesh. In that, civil court disputes, in terms of land disputes, etc., is one thing. But when we're talking about commercial disputes, in the context of contracts between parties, enforcing them, something going wrong in a complex contract, damages, awards, etc., we really don't have much of an effective system in the rest of the country at all. Let's be clear. The only way you can probably realistically, in a reasonable amount of time, seek to secure an award in your favor or an amount in your favor is an arbitration process. Because one of the big other problems which we have in India is we have something called an ad valorem court fee. So the court fee, which you have to put down in litigation, is scaled or is dependent on the amount which you seek to recover. And that closes out, I think, in a realistic sense, going to a civil court. So again, if you have a large or substantial claim, what you're left with essentially doing is putting down a huge amount of money and then litigating for a very long period of time. Or if you have an arbitration clause, having recourse to arbitration. So I think what I'm suggesting is that arbitration is really the only effective, reasonable manner. I'm talking, of course, there are exceptional courts which may be able to dispose of commercial disputes in a short period of time. But this is the norm across India. So in a situation such as now, the other point with regard to non-interference, which is very important, is, I think, first and foremost, a shift insofar as the judicial mindset is concerned. So just as it was suggested that perhaps we need to appoint younger people, as arbitrators, That's one aspect. The other is that you have to realize as judges that if you are going to eventually trust an arbitration system to operate, there will be, in your perception, some injustices which will have to be ignored. Because if you're going to look at it from an appellate review point of view, I think you're in huge difficulty. And I think what happens in India and what has happened in the past has been that we have a large number of public sector enterprises, which are essentially government-owned or partly government-owned enterprises. And when those face huge awards, I think if it's a dispute between two private parties, probably the court will say that, all right, we'll adopt a hands-off approach. But oftentimes I have found, and that's the track record of our Supreme Court, that there is a tendency or a propensity to interfere to try and shield a public sector company from an award, not in all cases, but in cases where there's a suspicion that there was some doubt with regard to the integrity of the process. Now that's very important, because if a court suddenly feels, and it weighs on the conscience of the judge, that look, I don't think this could have in all good conscience been awarded such a large amount against the public. So then the judges get tempted to open up a small little, exception. And then those exceptions in the hands of, competent lawyers, etc., tend to expand. So you're quite right. We are at a phase where we are trying to narrow judicial interference, but I think it's a mindset issue. In my study of the Supreme Court judgments over the last 4 to 5 years in India, you do find this mental shift that, all right, we are going to try and align ourselves with the global norms as far as arbitration are concerned and adopt a hands-off approach. That combined with, I think, the time frames plus institutional arbitration getting a fillip, I think it seems to me that we have a very good future and a good direction for growth in terms of institutional arbitration in India. And that's the only way I see forward for resolving commercial disputes, apart from that very valid point which was made with regard to mediation. Because I think with the degree and the number of disruptions in business which the pandemic has brought about, I think you will have to have first stage a negotiated settlement naturally between parties, but otherwise institutional mechanisms to facilitate that process, because no judicial system is going to be capable to handle every dispute if everything lands up there. So I think this is a very important time to also strengthen our mediation machinery and to try and see if that can deliver.
Thank you, sir. I think that's very important. And as you said, if institutional arbitration is the future, so I'm directing to Shweta now. See, if institutional arbitration is the future, as Mr. Diwan says, is there an issue? Is there a problem with party autonomy? Is one institution, the court, getting kind of replaced by another institution, i.e. these arbitral institutions, which have very strict rules of how to conduct arbitrations, timelines, and rules of how to file, etc. And are we kind of deprioritizing party autonomy, which was one of the most important advantages of arbitration? That's one question, Shweta, for you. And also, if you could shed some light, and I know you're not based in Singapore, but since you are working for a Singapore-based organization, what has Singapore done right in terms of which has established it as a regional hub for arbitration, and what can we do in Bangladesh or India to kind of achieve that level of success, or at least go close to it?
So I think both the questions can have 2 webinars each. But I'll try and share as much as I can given the limited time. So first is to understand what does an arbitration institution actually do when it is administering an arbitration. how much of that party autonomy is being curtailed, what is truly the function of an institution. So in simple words, an institution is a gatekeeper for the arbitration. It is not overriding what the parties have intended. It is still very much a process which is determined basis the agreement of the parties, what the parties have chosen. The institution will try and give effect to as much as to the choice of the parties. But the problem of ad hoc arbitration, or the example that you cited, that someone came up to you and said, wanted to have arbitration, but it's very expensive, is primarily because it must be an ad hoc arbitration. So you're not able to contain, there is no way to watch what is happening in the proceeding itself. So starting with your appointment of arbitrators, of course, the parties have the right to nominate even in an institutional arbitration, but the institution has the right to confirm. So it still reserves that power to ensure the quality of the arbitrator is intact. There are certain timelines which are there, but also if in an exceptional case scenario, if for whatever reason the party needs to extend some bit of timeline here and there, it can make request to the institution. Then again, of course, your financial bit is taken care of. Very importantly, how institutions directly or indirectly, let me use that word, tax the arbitrators if they don't function properly, which you can't do in an ad hoc arbitration. So more than taking away party autonomy, it is to ensure that the arbitrator does the job that it is meant to do. And lastly, a very important function of an institution is to scrutinize the award, to make it more enforceable. In fact, the credibility of an institutional award is so much more, and which I'm sure Mr. Devan will attest to it, given that he must be arguing so many applications basis these awards for enforcement, is how the court looks at an award which comes from an institution versus an ad hoc. So there is a lesser tendency to want to open up or to interfere with an award which has been made by an institution. So the function of an institution is so much more, and I think particularly maybe from Bangladesh and even from India's standpoint, of course, in India, there has been a significant shift to institutional arbitration. At least we are talking about it more. The government is doing more about it. So there is a conscious effort that is being made. But at the same time, this misconception needs to go away that institutional arbitration is more expensive than ad hoc. It is an absolute myth. In fact, there have been so many studies that have done which have given this breakup of how much cost actually comes out to be for what the institution charge, and how much do you actually save in an institutional arbitration versus an ad hoc scenario. So having said that, if you look at Singapore's story, I think we all learning from each other in terms of jurisdictions of what we've done right and what we can do better. And, and I think for Singapore also, they're still a long way ahead. They've come far, but there is still a long way that they can take forward. One conscious decision, I think, for Singapore that has worked really well as a model is how everyone has worked together to build this arbitration environment, to be able to promote that way, including the legislature, the judiciary, the arbitration institution, the hearing facilities. So a lot of these factors together have come to make Singapore truly a hub for dispute resolution or a hub for international commercial arbitration. So if you look at, in terms of legislative amendments, if you look at the history of their International Arbitration Act, the changes that have been made with time to ensure that all these restrictions that were there, including even where the foreign lawyers can participate, changes like these were also instrumental, to allow for more cases to come to Singapore, and very importantly for the judicial intervention. In fact, when I was practicing as a lawyer, and we were looking at, when drafting a clause, looking at a seat, and while we were negotiating with a counterparty, a foreign counterparty, the question really came that, we would like to have a seat which will not interfere in the decision that comes out of the arbitration. right? That's the whole point of going to arbitration. If you're going to run through different layers of appeals and opening and etc., then it defeats the whole purpose of going to arbitration in the first place. So because Singapore has this conscious approach of not interfering, minimal, absolutely minimal intervention in decisions. In fact, we did a study as a lawyer, when I was a lawyer, about the decisions of the Singapore courts. And I don't remember a number, but there were very, very few exceptional cases where Singapore had actually opened up awards. They had refused to interfere with the awards and allowed them to be enforced just the way it was. So I think that has been a huge factor. And of course, there have been recent amendments on third-party funding that has been made in Singapore, where they've allowed to legally recognize third-party funding. So to be really stay ahead of the curve, to be able to take the decision that you need to take ahead of the time, I think that has allowed Singapore to develop itself in the way it has. So I think that process will continue. Even Singapore can't sit back on what it has done. It has to be on its feet even now more than ever to ensure that it continues to provide that sort of environment, where arbitrations, where parties are truly satisfied that they have a neutral, the rule of law is upheld, and can have a dispute resolution which truly satisfies the parties.
Thank you, Shweta. That is very very important what you said, and yeah, I think I think this is a great time for a poll. So this is a second and last poll, just launching it very quickly, and again, panelists can vote as well. So the question is, in 2030, what would be the most preferred mode of dispute resolution? And so it's a very simple question, So we'll give it a few seconds, maybe 30 or 40 seconds for everyone to vote. And we'll open Q&A after this. Let's see. Okay, let's see. Oh, I think, okay, I think arbitration and mediation are tied together. Okay, so so moving on to questions, I'll start it off. We'll have 3 or 4 questions. I'll start it off, and my question is to well, anyone can take it, but is directed to Mr. Divan at first. Is that so Mr. Mustafizur Rahman Khan has mentioned that arbitrators are arbitration practitioners are kind of these, we were still part-time practitioners where you're doing court in the day and going to arbitrations in the evenings and Saturdays and whatnot. So what, but in general, what should an emerging practitioner now, who's someone who is just out of, just joined practice and is interested in arbitration, how should they kind of prepare themselves for the next decade if ADR is the future?
Well, I think many of the skills, as I see them, at least coming from in my country, we now have post my graduation, we have a large number of good national law schools where they impart a high level of training, and I think there's a general upgrade in the quality of education. But I think the sort of learning which you have in a lawyer's chamber cannot be provided in however good a law school you might have. So I think to your young viewers, I would say that if it's going to be arbitration which you're looking for, or potentially, and I think the first thing to do is to probably join a chamber which does some degree of arbitration work, because it's not very likely in the manner in which our professions are structured that you're going to develop an arbitration practice without actually being with a senior lawyer who has some element, at least, of arbitration work. I also do see in India a specialist arbitration bar developing over a period of time. And I think that's a very healthy development in some measure because of the time schedules which are there. And also, I think institutional arbitrations, because the institution will monitor. There are not too many arbitrations which are assigned to X or Y or Z. You will have better disposal, and therefore the arbitral panel will itself start insisting upon a full day's hearing during the day. And the only way you can get that is if you're going to, as practitioners, leave the court. Then I think the other element which you require is, I think, if you want progression in terms of the arbitration bar, I think it's important that recognition and distinction. So at least in the India context, we have under our Advocates Act, a designation system of senior advocates. And if you have, or elevation, say, to become a judge in the High Court. So these are standard channels for progression in the profession. And I think we will then have to develop some method of communication between arbitrators, arbitral institutions, and those who designate or those who decide to elevate persons onto the bench, to open up these dialogues so that people who make a conscious choice of taking up arbitration work are not cut out and completely eliminated from these areas of practice. Because I think the sort of commercial experience you might get as a practitioner before and as an arbitrator, you may not be able to get in other fields. And so a judge who is elevated to a judge on the bench who has this kind of experience, I think would be very, very valuable. So I think we need to really work and redesign our system to the extent possible. And for young persons, I can only say, and practitioners, that if you're looking at a practice in the future in terms of arbitration, a good way of doing it is to first initially join a senior practitioner who is in that field. And the other is probably to write and, to critique these systems, because in a profession like ours, where you cannot really advertise, but you can certainly lend scholarship. I think that's one good way of getting known in the field. And I think being abreast with international developments in arbitration would be certainly very, very advantageous to a young practitioner.
Thank you, sir. Musafi sir, would you like to add a little bit to that and also take a question from Zakir Chaudhary, which is, assuming that online hearings stay in the post-pandemic era, what stages of litigation do you think could be held online and which ones must be held in physical courts? So I guess in this scenario where we have for VCs or virtual courts are still there, and what are they actually doing in that
I think to answer the question first, I think at least to begin with, interlocutory applications can be dealt with through virtual hearings. As far as even ad hoc arbitrations are concerned, preliminary hearings can be held virtually so that the fraternity becomes more familiar with the process and let it develop organic, and after that it can develop organically. But I think what is important in Bangladesh, particularly in a Bangladeshi context, it is to show the success of institutional arbitration. Now, the example that comes to my mind is the experience of what was known as the Liverpool Cotton Association, is now called the International Cotton Association, where you have paper arbitrations, disputes between members of the International Cotton Association, who are typically cotton suppliers, and the purchasers. They insist that the contracts have a International Cotton Association arbitration clause, and the arbitration mostly, even if it relates to quality, they have a particular protocol where the quality of cotton is very easily tested. For instance, if it's a quality dispute, there is a paper submission to an arbitrator, usually somebody who is nominated in, it is seated in Liverpool, and somebody who is professional in the field. And the cost of those arbitrations are very low. I mean, in the range of £2,000-3,000 even, and you can get an arbitration over with. What is, I wish that, I mean, it would have been good if Mr. Rumee Ali was still present. I think one of the ways in which institutional arbitration can be promoted in Bangladesh is that if BIAC, for instance, were to work very closely with one or two of the industry associations and convince the members of those industry associations to refer disputes arising out of at least certain categories of contracts to an institutional arbitration, and demonstrate from reference to resolution is only 6 or 7 months. And if they can demonstrate the speed, the expeditiousness of the process, then gradually it will catch on. So this is what I think is very important. And in that process, to take a cue from what Mr. Divan said, in Bangladesh also, one of the big crises at the moment in the country is that there are, in Bangladesh, our Bar Council at the moment has 70,000 lawyers. But even as we speak, over the past 4 years, because of the rapid expansion of legal education in Bangladesh and a large number of lawyers who have returned from abroad with legal education, there are now up to 70,000 pupils who are in queue to join the legal profession. And the Bar Council is also facing certain challenges in conducting examinations for enrollment. But we have to think ahead. Once all these young boys and girls come into the legal profession, how do we accommodate them? I have spoken with many of them. They are young. I'm 48 years old now, so they are about 24 years younger than me. And they're very bright. They are raring to go. They are very frustrated because of the prolonged period of time that it is taking for them to join the profession. But I think if the institutional arbitration forums were to tap on into that resource, then within 5 years, 6 years, I foresee that we can have the sort of human resources that we would need in order to develop a more efficient system of commercial dispute resolution.
Thank you, sir. Shweta, there are a couple of questions directed at you. So there's one from Karma, and the question is what was the biggest challenges that SIAC witnessed in terms of proceedings, and do you believe that SIAC is cost effective in comparison to traditional litigation? I think you've answered that to an extent, and also there's another question regarding whether SIAC has any plans to start online arbitration. That question is from Wahid Sadiq Khan. And are you making separate rules for it?
So currently, there are no plans to make like completely an online dispute resolution, but we have moved electronic in a lot of ways. In fact, if you've seen the recent news, SIAC is also opened up for consultation on revising its rules. And one of the factors to revise its rule is to take into account technology, the use of technology in arbitration. So that's up for revision. And of course, it will depend on the whole revision process. What are the comments that are received from different stakeholders? And but not at the moment going completely ODR, but everything's moved electronic in that sense. And the hearings have, of course, gone online.
Thank you. I think we've reached at the end in terms of time, at least. I think we may have missed a couple of questions, but I won't keep you any longer. Thank you, because your time is extremely valuable. I understand that. And thank you so much for giving this past 1.5 hours to us and our audience here registered on Zoom, and also on, who are watching on Facebook Live. Thank you, Shweta. Thank you, Sham Divan sir. Thank you, Mustafiz sir. I hope you have a lovely evening ahead. And also thank you to the participants for being patient with us and listening. And yeah, thank you from Mahbub Company. And I hope you are all in good health in the coming months.
Thank
you
very
very much, Saqib.
Good evening.
Panelists. Thank you. Thank you.
Good night.
Thank you, everyone. Forward to meeting you all in person. Bye. Good night.
Goodbye.
If there is at all a time where we can do that.
Thank you.
Thank you. Bye-bye, sir.